The Federal Circuit Courts of Appeal are starkly in disagreement with 8 bankruptcy judges on an interesting and important question of consumer bankruptcy law. Here's the question. If a Chapter 13 case is dismissed before the debtor confirms the Chapter 13 plan, is the Chapter 13 trustee paid or not? Well, we now have the 7th, 9th, and 10th circuits all holding that the Chapter 13 trustee is not paid if dismissal precedes confirmation, regardless of however much work the Chapter 13 trustee may have devoted to the case. On the other hand, we have 8 bankruptcy courts which held quite to the contrary and concluded that Chapter 13 trustees should be paid if dismissal precedes confirmation. Well, this is I'm going to call it difficult case of statutory interpretation. So we have Article 3 circuit judges reading the statute one way, and at least 8 bankruptcy judges, including the 9th Circuit Bankruptcy Appellate Panel, which draw an entirely different conclusion from the same words of the statute. Well, the question may or may not be going to the U.S. Supreme Court within the next year because the identical question is currently pending before the U.S. Court of Appeals for the Second Circuit, which sits in New York, New York. In that case, the bankruptcy court had ruled that, in fact, the Chapter 13 trustee is paid. And that decision was affirmed in district court. And at that point, the case went to the Second Circuit Court of Appeals. Here's what's really interesting. That case was argued on February 15, not February 15, 2024, but February 15, 2023. In other words, approaching 16 months ago. One has to wonder, with the Second Circuit taking so long to issue an opinion, are they about to disagree with the other 3 circuits and say that Chapter 13 trustees in fact are paid? Now this is a difficult question for the Second Circuit because they very well know that if they create a circuit split, there's a very good chance that the Supreme Court is going to grant certiorari and review all 4 of those decisions. And of course, the Second Circuit, if it takes the contrary position, is in the minority. And those judges are going to worry that if their case goes to the Supreme Court as it would, well, they run the risk of being reversed by the justices of the Supreme Court in Washington, D.C. We'll just have to stand by and see what happens with the Second Circuit decision. And of course, as soon as it comes down, I will be reporting that opinion from the Second Circuit within a matter of a day or so. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. I shall return next week, same time, God willing, with something interesting or important from the world of bankruptcy. Until then, good day, be well, stay safe.